Hey Ravi, just a second.
वांधा नहीं.
Okay, so we are live now with 91 participants in
Yes,
total.
yes.
Great.
Hello. Good afternoon, fraternity. Once again, SHRP brought you one very relevant topic of Occupational Safety, Health and Working Condition Code 2020. I think there are a lot of discussion on other codes, wage code, IR code, social security, but I think this code is yet not explored by anyone. So I think this is very golden opportunity for all of us, not only for HR, but IR and safety professional also. Today we have very distinguished speaker on our board. So I would like to welcome Palkar sir and Shailesh by Raval sir. I would like to introduce Palkar sir.
Thank you.
Palkar sir is actually MSW from MS University and also LLB, having 35 years of enriched experience in HR, IR, and legal. So I think we have the expert faculty for the HR, IR, and legal, and all are mostly knowing about the Palkar sir because as a HR fraternity, because he has worked with LMB, Rubamin, JCT Electronic, Sun Pharma, FAC, Stel. So he have play a leadership role each and everywhere. And he is very good faculty, actually very good in IR. So we have Palkar sir as combo of HR, IR, and legal. So we have to learn so many things from Palkar sir. Palkar sir is also Vice President of NHRD chapter of Vadodara. Sir, welcome Palkar sir. And
Thank you.
Shailesh bhai Raval is also one of the expert faculty in safety. Actually, Shailesh bhai is B Environment from Gujarat University. He having a diploma in industrial safety, auditor for the responsible care, QHSC management, and ISO system also, and trainer for the responsible care, behavior safety, QHSC management system, TQM, green productivity, and business excellence. So I think in both field we have the master speaker in both field, HR and safety. So I don't want to waste lot time because I would like to say about our society also. And I will first of all I would like to thank Mr. Bhavin Shah of I Am Possible because he provide our platform for the webinar, and every time he is providing. So thank you, Bhavin bhai. Secondly, I would like to thank Crown HR Services of Mr. Prahlad Joshi. He is always ready to support us. Third thing, SHRP is up till doing a lot of webinar and everything. Last in November, webinar of the Dr. DC Bakshi and Atul Chaudhary on wage code and IR code. So it is our attempt to give maximum to HR fraternity as far as the possible. SHRP actually established 2 years back by two young HR professionals, Nishant and Ashish Soni. They have the vision कि they actually उनको ऐसा था कि इंडस्ट्रियल जो एजुकेशनल में जो गैप है, they would like to fulfill this gap by imparting training, education, and different types of programs. So this actually objective of this SHRP is only for that. But apart from that, SHRP has started one woman wing also for the community development, community issues, and recently we have adopted one village near Vagodia, Amodar village, and already we have started activity also. So SHRP is trying to give best of the best to the society and HR community. So I don't want to waste more time about this thing. So I would like to hand over the session to the Palkar sir. Thank you very much, Palkar sir.
Yes. Yeah. So, thank you, Hiren bhai, and I welcome everyone for being present and giving some time. And SHRP is doing a great job, friends, and leadership of Mr. Soni and Hiren bhai and the team You have done fantastic job, and I am so much impressed with this. Am I audible?
Yes, yes, sir.
Okay, so this is really a great platform, and whenever Hiren Bhai has some request, or I don't want to say the word request, he has to order me, and I am always there for any good cause, because he is really a committed person, and entire team of SHRP is really committed. So friends, I think we will now move to the presentation of the code. So what has happened? These slides are there. We will not read all the lines and all the words of the slides. Whenever there is something required, I will elaborate on that, because all of you must be having now the codes, the code books you must have purchased. So you can always go through that whenever it is required. Today, what we will do is that we have used this as a backup, and we will keep on using these slides as and when required. Okay, so friends, all of you are aware that since 2019 the government is committed to one mission, that is ease of doing business. And because of this particular aspect, there is a lot of international pressure also on the government for for India to be an investment friendly country. And because of this, there were a lot of outdated provisions were there in all the labor laws. So the government had a vision, and for all the 44 labor laws were there. Out of that, this is a list of 33 labor laws which have been now clubbed together, and all these existing laws, they have been repealed in these codes, and 4 codes have come up. Now, I think this is a Occupational Safety, Health and Working Conditions Code. This is a very, very important code, and I think all of us must be aware of this, because I would say that as far as labor laws are concerned, there are 3 to 4 major labor laws which are a nucleus of the IR. One is the Industrial Disputes Act. So you have already covered that under the IR code. Secondly, the Standing Orders Act, that is also very important, because the conditions of employment and other things, they are specified in that. So probably that has been taken care of. Now, similarly, in today's time, when we started our career, we had an IR which was of a different nature. Now, IR is generally revolving around the contract labor issues. So, contract labor has been covered by the Occupational Safety, Health and Working Conditions Code. So, we will be talking about Contract Labor Act also in this, and the Factories Act, because Factories Act has got a lot of important provisions which have really been addressed by the new code, and which will really have implications on the employers across the industry. So some of the major implications would be, all of us are aware that there is a provision of creche in the existing Factories Act, which has now been repealed. All these codes are likely to get implemented from 1st of April 2021. So prior to that, we will be governed by the existing laws. So the Factories Act, which has a provision of creche, which is about which says about 30, when there 30 women employees are there, the occupier is required to make provision for creche. So that has been now changed. So it is now 50. So I am just highlighting these, some of the provisions. Provision of welfare officer, that has also been amended. Provision of canteen, that has been amended. So all these things are going to get affected. There is a lot of talk about, you must be reading in the newspapers and some articles that now the managers will be entitled to overtime and all that. So all these things are there. Right now, there are a lot of things which need clarity, and the clarity will definitely be achieved. It will take some time. When any such major thing is happening, friends, there is bound to be a lot of confusion also, and somebody will say something, somebody will come up with another thing. So that is bound to be there. Especially now, one more aspect to you, all of you must be aware in today's context, when the codes will be there, the wages definition. Okay, so wages definition again is very important, because many people have not yet understood the aim is, and the effort is to make it very simple. But okay, and the intention is also there, but friends, it is not so simple as we are saying, because so that is one aspect which I might try to cover towards the end of my this session. Okay, now, so yeah, Fagun bhai, can you move to the next slide? Okay, so friends, this is a list of the 13 labor laws. Of course, many of them we are not really concerned, because Mines Act we are not really required much to know, because we are not working in mines. Interstate Migrant Workmen Act, there are certain provisions I'll discuss slightly at length, and you can say the Factories Act, we will talk a lot on this. BOCW Act is also very important. All of us, we should know. So as and when the slide will appear, I'll just highlight on that. And and Contract Labor Regulation and Abolition Act, which is also repealed by this code, but it has got certain important provisions which have been incorporated in the act, because there are certain activities for which the contract labor can be engaged. They have been specified. So this is a list of 13 acts which have been repealed now, and against that one code has been included. Next. Okay, now basically the objective of the codes is, friend, it is simplification, then the amalgamation of various labor law provisions, then rationalization of the provisions. So this is an important thing. Then apart from that, to impart flexibility in adapting to the technological changes and dynamic factors. This is very important. Then to apply the provisions of the proposed code for all establishments having 10 or more workers. This is very important, other than the establishments relating to the mines and docks. Then to provide a concept of one registration for all establishments. So this is also one of the objectives, one registration for establishments having 10 or more employees. However, for the applicability of all other provisions of the code in respect of the factories, except registration, the threshold has been made. For the Factories Act, it is 20 and 40, friends. And for in case of any other establishments, it is 10. Then to include, this journalist, we will not talk much about it. To provide issuing of appointment letter is mandatory by the employer. So this is an important provision. Remember, this we will have to keep in mind. And to provide for the cost of annual health checkup for employees. So this is for the elderly employees. You have to bear, as an employer, will have to bear the cost of medical checkup. The next one. Yeah. So this is another slide I will just go through. This is again the objectives of the code we are seeing. So to enable the provisions relating to the interstate migrant workers applicable on the establishment in which 10 or more migrant workers are employed. Now, who are the migrant workers? That is also made clear by the act. We will just see as and when it's there. And so interstate migrant may register himself as an interstate migrant worker on the portal on the basis of the self-declaration and Aadhaar. So this is an important thing. An interstate migrant worker has been provided with the portability to avail benefits in the destination state in respect of ration and availing benefits of building and other construction workers. So this is again about some of the objectives. To constitute the State Occupational Safety and Health Advisory Board. This is also one of the major points. Then to employ women in all establishments for all types of work. So there is a provision relating to the women also, and women can also work in the night shift. That provision is there. So these are some of the objectives. Can we move to the next one? Yeah. Now, the scope of the OSH code, this is a scope. So the code is applicable to every establishment, industry, trade, business, manufacture, or occupation employing 10 or more workers. And a factory, motor transport undertaking, newspaper establishment, audio video production, building, and any other construction work or plantation in which 10 or more workers are employed. And it is also applicable to the mines. So the idea is that one common code regulating service, manufacturing, any other business and a trading activity and ease of doing business. This is very important. The next one. Okay. Now we will just quickly see the salient features. The bill was passed in September 2020 and consolidated different laws keeping in mind health, safety, working conditions of workers, establishments employing 10 or more workers, factories employing 20 or 40. There is a threshold limit, and IT continue to remain outside the Factories Act. So IT is not a part of the Factories Act. And to include audiovisual, cine, theater workers in electronic media, including e-papers, radio, etc., interstate migrant workmen, inclusion of grandparents within the definition of this is a very important feature, friends. Concept of one registration for establishment, common license for factory, contract labor, and BD and cigar establishment for 5 years. This is very important point which is there. We don't have to now go every year for getting the license and the renewal, and this is what it is. Then providing for national and state occupational safety and health advisory board for advising the government. The next one. Okay. Constitution of Safety Committee, women working in night shift. This is another one. Crash, I already talked to you. Then to enable court to grant up to 50% of the penalty as compensation, as a compensation to the victim of the accident. This is a very important thing. So the act is taking care of the human being and the human aspect and the legal here in case of the worker who died. Then to provide for adjudging the penalties imposed upon the code and provision for the officers of the appropriate government to impose penalties in some cases, and composition of certain offenses. This is a very important provision. By composition, the employers will be given an opportunity whereby they will say that okay, they will plead guilty, and then the prosecution will be avoided. So Social Security Fund for the welfare of the unorganized workers. Unorganized workers have also been included in this code, friends, to receive fines from the composition of offenses and other sources. Next one. Okay. The object of the OHS code, that is Occupational Safety and Health and Working Conditions Code, is this is an act to consolidate and amend the laws relating to the occupational safety, health and working conditions of the persons employed in an establishment and for matters connected therewith or incidental. So idea is to consolidate and amend the laws relating to safety, health and working conditions. Yeah, the next one. Okay, so we will just this appropriate government definition. I think all of us are aware there is not much of a change. So appropriate government definition. I would what I'll do, this presentation through SHRP you can share to our fraternity, no problem, so that whenever they have something, yeah, okay,
sure, I will share, no problem.
Oh yes, fine. And the whatever questions you have, we will discuss towards the end of the program, and if we cannot address all the questions, you can give these questions to basically to Hirenbhai SHRP, and we will definitely give all the consolidated answers in a week's time. Yeah, the next one.
Thank you, sir.
Yeah. Okay, section 2G. So section 2G is again a definition. Building and other construction work does not include any building or other construction work of any factory or mine, or any building or other construction work employing less than 10 workers. So existing buildings and existing factories, their construction activity will not be under the purview of this act. The next one. Okay. Establishment means a place where any industry, trade, business, manufacturing or occupation is carried on, in which 10 or more workers are employed, or motor transport undertaking, newspaper establishment, audiovisual production, building or other construction work, or plantation in which 10 or more workers are employed. Factory for the purpose of the chapter 2. Chapter 2 is one has made one provision in which even if it is a factory employing less than 20, so 10 or more workers are employed, notwithstanding the threshold of workers, that is also included in this. And I think that's all. Move to the next one. Okay, so definition of the factory. So factory means any premises, including the precincts thereof, wherein 20 or more workers are working, 20 or more, or were working on any day of the preceding 12 months, and in any part of which the manufacturing process is being carried on with the aid of power, or is ordinarily so carried on, and whereon 40 or more in without the power. So this is the definition given this. And computing the number of workers for the purpose of this clause, all the workers in different groups of relays in a day shall be taken into account. So fine. The next one. Okay, contract labor. Contract labor has been now defined. So contract labor means a worker who shall be deemed to be employed in or in connection with the work of the establishment when he is hired in or in connection with such work, or through a contractor with or without the knowledge of the principal employer, and includes an interstate migrant worker, but does not include a worker other than a part-time employee who is regularly employed by the contractor for the activity of the establishment, and his employment is governed by a manual standards of employment, including engagement on permanent basis, and gets periodical increment in pay, social security coverage, and welfare benefits in accordance with the law for the time being in force. Yes. Next. Okay. This interstate migrant, who is an interstate migrant worker? So he is a person who is employed in an establishment and has been recruited directly by the employer or indirectly through a contractor. So interstate worker can be also an employee who is directly employed by the employer and also by the contractor, and in one state for employment, and in such establishment situated in another state, and has come on his own from one state and obtained employment in an establishment of another state. So this is very important. From one state to another state, he has to get the employment, and has subsequently changed the establishment within the destination state. So there is a destination state. So if he's from some different state and working in a destination state, he is a migrant worker. Fine. Next one. But here the 18,000 rupees ceiling is there, friends. So remember that anybody who is drawing more than 18,000, even if he is working from one state and working in a different destination state, he is not a interstate migrant worker. Employee has been defined by this code. So employee means in respect of an establishment, a person other than an apprentice. Apprentice engaged under the Apprentice Act is excluded from the definition of the employee. Employed on wages by an establishment to do any skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, and administrative, technical. Managerial employees are also employees under the code. And worker means any person employed in any establishment. Worker has been, specifically the words excluded in the worker definition are the managerial and administrative, whereas most of the things are clear. The next one. Sales promotion employees, fine, they are also covered by this act. They are mainly, into the pharmaceutical trade, or these are the people who are in this. Next one. Core activity, this is about the Contract Labor Act. So what is a core activity of an establishment? Core activity of an establishment means any activity for which the establishment is set up. So this is very important. core activity is any activity for which the establishment is set up, and includes any activity which is essential or necessary for such activity. If that activity is not being done, the very existence of the establishment will remain at stake. So provided that the following shall not be considered as essential or necessary activity if the establishment is not set up for such activity. So these are the activities which are not considered as essential. So sanitation work, including sweeping, cleaning, dusting, collection of disposal. So watch and wards, that is our security services, they will not be included. Canteen and catering services, they are excluded, friends. Loading and unloading, this has been excluded. Running of hospitals on edge. So these are the activities which have been basically very specifically considered as activities which are not essential. So this is very important. Now there are in the past there are several Supreme Court judgments, very famous judgments, starting from Air India Corporation to Steel Authority. So all these judgments, they were in many cases, even some of these activities which were not essential, but then they were considered as part of, the perennial nature. So probably that risk will get averted. So this is a good, provision which has come, and which will be sort of it will help the employers. The next one. Now, occupier. Who is an occupier? So occupier of a factory means the person who has ultimate control over the affairs of the factory, provided that in the case of a firm or other association individuals, any one of the individual partners or members. In the case of a company, any one of the directors, except the independent director within the meaning of subsection. So independent director, which was allowed by the existing Factories Act, now he will not be an occupier. So this is a very important thing. So then person who is an occupier has to be one of the board directors. He cannot be, independent director will not be considered, friends, as a occupier. In the case of a factory owned or controlled by the central government or the state government or the local authority, the person or persons appointed to manage the affairs of the factory by the central government or the state government of the local authority or such authority as may be prescribed by the central government, he shall be deemed to be a director. The next one. Fine. This is the definition of industry. Industry has been, this is similar to the definition which is already there in the ID Act. So it's a systematic activity carried on by cooperation between the employer and the workers, whether such worker is employed by such employer directly or through any agency, and including a contractor, for the production, supply or distribution of the goods and services with a view to satisfy human needs and wishes, human wants and wishes. So this is very important, whether or not any capital has been invested for the purpose of carrying on such activity, or such activities carried on with a motive to make or gain profit. This is very important, but does not include any domestic service or organizations carrying on charitable or social or philanthropic activities not in the ambit of industry. Fine. The next one. And now, see, there is one provision for duties of designers and manufacturers or importers or suppliers and architects, project engineers and designers. So this is in most of the industries, wherever the equipments are there, who are the designers. So this pertains to them. So Section 8 specifies that certain duties have been cast upon the manufacturers and the designers or importers or suppliers, and holds them responsible for the safety. Of course, this Mr. Shailesh Raval can explain throw more light, but I'm just explaining to you. For the safety of the equipment and material designed, imported, supplied, erected, installed to be safe and without risk to the health of the workers when properly used. So there are details specified wherein which were not covered in the existing legislation. So this is a very important provision. And Section 9 in detail specifies the duties of architects. Architects are also covered. Project engineers, designers, and they hold them responsible, because many times some disasters have happened, friends, and the government also has experience out of these incidents, and that is why this provision has come up. The next one. Yes, so this is a chapter about the registration. So section 3.1 is the B, which says within 60 days from the date of the applicability of this code. Now this code is likely to become applicable on 1st April unless something else happens. Otherwise, most probably this will come from 1st April. So within 60 days from 1st April, we have to get the registration. Change in ownership shall be intimated by the employer electronically to the registering officer within 30 days. So any change in the ownership is there, within 30 days it has to be electronically informed. The employer of an establishment shall, within 30 days of the closing of the establishment. So about the closing of the establishment also, there is a responsibility which the employer has to do, and notice of employer of commencement or cessation of operation electron. So all these are to be done electronically. Next one. Fine. This is about some welfare facilities. So section 24. So we have currently in the Factories Act, I think section 40 onwards, they relate 41 onwards, they relate to the welfare. So here this has become section 24 with certain changes, So this is about the washing place and bathing place, and it talks about the clothing, drying and place for keeping clothing, then sitting arrangements for all employees obliged to work in a standing position, facilities of canteen in an establishment for employees thereof, wherein 100 or more. Current provision of the canteen is 250, so this has become 100 and more. So this is going to cast a lot of responsibility in the smaller type of companies, friends. Then adequate first aid boxes, this is already there. Any other welfare measures which the central government considers under the set of circumstances as required for decent standard of life. Okay, the next one. Yeah, this is about the welfare officer, welfare facilities. We are continuing with that. Central government may also prescribe the following matters: ambulance room in every factory of more than 500 workers. Then medical facilities, adequate, suitable and separate shelters or restroom for male, women and transgender. Transgenders, I think all of you are now aware, they are also included in the code. So this is the first time which has happened. So there has to be a separate shelter room for males, separate shelter room for females and transgenders. So this is very important. Then the appointment of welfare officer in every factory, wherein previously it is the existing provision is 500, which will now be 250 or more workers are when they are ordinarily employed, and any other matter which may be prescribed. So that any other further matter can also be included in the welfare measures. The next one. Okay. The next one. Now this is about the hours of work. So no worker shall be required or allowed to work in an establishment for more than 8 hours of this. And then, okay, the period of work each day under clause A shall be so fixed as not to exceed such hours, which with such intervals and spread over. So that will not be included in this. The next one, this will be notified by the government. Of course, weekly off and this everybody is aware, so will not take much time. Yeah, we can go. Extra wages for overtime. There shall be paid wage at the rate of twice the ordinary rate of wages in respect of overtime. So this is there where a worker works in an establishment for more than 9 hours in any day or more than 48 hours in any week. Explanation for the purpose of this section: ordinary rate of wages means the basic plus dearness allowance or any other allowance which is considered as part of wages. This is very important. I think I will explain to you the wages depending upon the availability of the time. I think wages definition I will definitely take some 2-3 minutes towards the end of this. Yeah, the next one. So this is about the annual leave with wages. One major change in this annual leave with wages has happened is that the qualifying period was 240 days or more. So that has been now reduced to 180 days, and 1 for 20 days is the same provision which has been continued. So fine. The next one. Encashment provision has been made, friends. And in case of such worker whose services commences otherwise than on the first day of the January, shall be entitled to leave with wages at the rate specified. So this is a good simple provision which has come. It has added some simplicity to the provision. Next one. Okay. In case such worker is discharged or dismissed, somebody is discharged, dismissed from the service, or quits employment, or is superannuated or dies while in service during the course of the calendar year, such worker or his heir or nominee shall be entitled to wages in lieu of the quantum of leave to which such worker was entitled immediately before such discharge, dismissal, quitting of employment, superannuation, or death. So these are the events in which the heir or the nominee of the person will get the money. And where such worker is discharged or dismissed or quits employment before the expiry of the second working day from the date of discharge or so this has to be paid or before the end of the second working day, expiry of the second. This is very important. Let's move to the next one. Okay. Now, without prejudice to clause 6, such worker shall be denied on his demand for encashment of leave at the end of the calendar year. So this is a very important thing. Please remember, such worker shall be entitled where the total number of leave exceeds 30 days under subclause A or clause 7, which is mentioned above, to encash such exceeded leave. Okay, he will be entitled to. Yeah, and the appropriate government may by notification extend the provisions of subsection 1 to other establishments except the railway establishment. The provision of subsection 1 shall not operate to the prejudice of any right. So any right will not get infringed to which a person employed in a mine or be entitled under any law for the time being. So this is there. And okay, the Soham, I think good point you mentioned. I could see that. We will address this separately. Yeah. Next one. Okay, maintenance of registers. And so right now there are multiple records and registers and returns which we are required to submit and maintain. So the effort is made to reduce and make them electronically also. This is the first time in the labor law they have mentioned about the electronic provision of this. Yeah, so this is a very good thing which has happened. So again, we will just see, an employer of an establishment shall maintain register in the prescribed form electronically or otherwise containing such particulars of workers as may be prescribed by the appropriate government. Now, appropriate government here will be the state government in our case. Most of the people who are working in our private type of industries, limited industries, so which have governed by the state government control, the state government will make the rule. And right now it is in the final stage. That is what has been conveyed to the certain official forums, and work performed by them, number of hours of work constituting normal working hours in a day of rest allowed in every period of 7 days. This is a provision which has happened. Wages paid and receipts given, then leave wages, everything will be covered by these registers. So display notices at workplace of the workers in such manner and form as may be prescribed. So wherever as may be prescribed is coming by the appropriate government, so things are getting finalized. Issue of wage slip to the workers in electronic forms. So this is a good thing. Previously there was a system, a procedure that whenever you have to get the electronic or some other means, the computerized record, then you have to take a permission from the labor department. So with these kind of provisions, that requirement will now go off. Then file such return electronically or otherwise to the inspector cum facilitator. Now friends, this word facilitator that has been added, so the idea is that he will really be a facilitator, and he is going to help the industries. He will come there and he will not only do the usual inspection, but his idea is to educate and make everyone aware, all the stakeholders aware about the provisions and the legalities. So this is a very important role has been given to the government authorities, and let us hope and let us have a faith that really the role will be of a facilitator, and that will happen. The next one. This is a appointment of inspector cum facilitator. So as and when the appropriate government will appoint the inspector cum facilitator. We already have in the government labor departments officials who are already working as inspectors. So they would be given this task of the facilitators. Yeah. The next one. Yeah. So this is again pertaining to the facilitator's role only. Yeah. The next one. Yeah, it is continuation of the same. So this I am going to share with you, friends. So there is no point in reading out word to word in this provision, because I have been explaining to you as and when it is warranted. So this particular slide we will not go through all the provisions. Yeah. Now every chief inspector cum facilitator, or additional chief inspector cum facilitator, or joint chief cum joint chief inspector cum facilitator, deputy chief inspector cum facilitator, inspector cum facilitator, and every other officer appointed under this section shall be deemed to be a public servant within the meaning of section 21 of the IPC, so Indian Penal Code, and he will have shall be officially subordinated to such authority as the state government may specify. So this is very important. Next one. So powers of the inspectors cum facilitators. So subject to any rules in this behalf, any inspector cum facilitator may enter with such assistance of persons, being persons in the service of the government or any local or other public authority, or with an expert as he thinks fit, any place he may enter, any such place which is used or which has been has a reason, which has a reason. Hello. Yeah. Okay, which he has a reason to believe is used as a workplace. He can inspect and examine the establishment, any premises, plant machinery, article, or any other relevant material. He can inquire into any accident or dangerous occurrence, whether resulting in bodily injury, disability, or death, or take the any on the spot or otherwise statements of any persons which he may consider necessary for such inquiry, subject to any rules made by the state government in this behalf. Within his jurisdiction, examine the crops grown in any plantation or any worker employed therein, or require the production of the register. So this is what is the power of. So they can go, they can inspect, they can do any type of an inquiry. So this is about the powers. The next one. Okay, he supply information and sensitize the employers and workers regarding the provisions of this code, which I already shared. Then he can require the production of any register. So he can ask for any register to any company or employer, any other document relating to the workplace and work, and he can search or seize. This power is there to the inspector cum facilitator. Search or seize, take any copies or any register or record or other documents or any portion thereof as he may consider necessary in respect of any offense under this code. So here, where whatever is required, he can ask for the record, in which case we cannot really deny, because it is his power given by the act and the code, and direct the concerned occupier or employer that any premises or any part thereof or anything lying therein shall be left undisturbed, whether generally or particular respect, for so long as necessary. So suppose there is some accident at any place and then some inquiry is required. So he can definitely make an order and direct the concerned occupier of not to use a particular section of that or part of that premises. So this is what is talking about. And fine. Then take measurements, photography, videography, all these things he has an authority to take. Take samples of any articles or substances found in any such establishment or premises into which he has powers to enter, and the air of the atmosphere in or in the vicinity of any such establishment or premises in such manner as may be prescribed by the appropriate government. So fine. So continue further. Okay. So this is again, there are a lot of exhaustive powers which have been given. He can prosecute, conduct, or defend any court or complaint or other proceeding arising under this code. So all these powers have been vested to the inspectors cum facilitators. Fine. Friends, I am going to share with you the PPT, and the difference between the Factories Act and this code. I will do one thing. I have got one more. I am not going to use this in this presentation. But what are the implications and what are the differences between the existing labor laws and the codes? Hereinby, I'll share with the fraternity. So I think everybody's question will get answered. The next one. Okay. So chapter 9 is about inspector cum facilitators and other authorities. So inspector cum facilitator, special powers of the inspector cum under section 38. For 3 days, he can prohibit the occupier from employing persons in a place considered by him as hazardous. If he considers that this place is hazardous, he can prohibit the employment of persons there. Workers will be eligible for wages in such case for the period, and the employer will be required. So whenever this kind of provision is exercised by the inspector facilitator and the workers are prohibited from working, then employer is liable to make the payment. This cannot be considered as a layoff or something like that. This is very clear. And section 37 talks about third-party audit and certification for startup and other class of establishments. Fine. Section 37 provides for a third-party audit and certification of startup establishments and class of establishment to get the same done and submit. So this is for the startups actually. Yeah. Okay. Yeah. Can we move forward? Yes, this is about the secrecy of information by the chief inspector cum facilitator or the inspector. So friends, remember this particular thing. So whatever copies or whatever documents, whatever registers these inspectors cum facilitators are taking or asking us, we have to provide them. But the responsibility is cast upon them to maintain the secrecy of the information which is available through these registers or records or any documents that they are asking for. So we can always, we can always have a point and discuss with them and take up if you feel that this kind of a secrecy has been breached anytime. So this is very important provision. And now nothing in subsection 1 shall apply to the disclosure of any information to any court. So these are the authorities where, this disclosure can be given, or any committee of the board is constituted under this code. These are the authorized authority. Only to them such information can be shared, whereas at other places, no, it cannot be shared. Yeah. The next one. Okay. Notwithstanding anything contained in this, friends, whenever there is a word notwithstanding, you substitute by the words in absence of. So that will make you easy understanding of the provision. So notwithstanding in absence of anything contained in the Right to Information Act 2005, no chief inspector cum facilitator or inspector cum facilitator shall disclose the source of any complaint made to him regarding the contravention of any of the provisions of this code without the consent of the complainant. So whosoever is a complainant, without his consent, this cannot be shared by any of the inspector cum facilitator, and shall also not, while making any inspection under this code in pursuance of such complaint, disclose to the employer concerned or any of the representatives that inspection is being made in pursuance of such complaint. So that can also not be discussed. The next one. Next one, please. Okay, these are the certain special provisions relating to the women which have been made. So section 43, women to work with her consent. So consent is required, friends, whenever the woman is required to work beyond 7 p.m. and before 6 a.m. So it is allowed, but the consent of the woman is required which is a legal provision. And adequate safety of employment of women in dangerous operations. These two things are special provisions with reference to the engagement of employment of women beyond 7 p.m. and 6 a.m. Yeah. Next one. Now, this is about part one of this. It is about the Contract Labor Act. I think we have seen many of the things and I have discussed also. So 45 to 62 of the Contract Labor and Interstate Migrant Act have been merged with this code. So the existing 45 to 62 of the Contract Labor and Interstate have been merged. Qualifying number is 50 instead of the current 20 of Contract Labor. So friends, whatever is the license requirement right now for 20, that will get substituted to 50. So up to 50, you will not be required to take any license or registration. Registration will be required, but license is not required. Okay. Now, section 45. Fine. Okay, fine. Yeah. Continue. So principal employer engages any contract labor through, and this is very important. If you are engaging a contract labor through an unlicensed contractor, then such contract labor shall be deemed to be contravention of the code, not deemed to be employees of the principal employer as it was earlier. So this is only a contravention of the code, and they will not be considered as the employees of the principal employer as per the existing provision. Then a contractor shall not be responsible for payment of wages to each contract labor employed by him. Principal employer need not appoint overseer to monitor the payment. Fine. So this is what currently, there is a provision in the Contract Labor Act wherein whether the contractor is paying or not, the representative of the principal employer is certifying that. So this has been removed. Then the next one is in case of go to the next. Yeah, fine. Now this is very important. Prohibition of employment of contract labor. Notwithstanding anything contained in this part, employment of contract labor in core activities of establishment is prohibited. So friends, right now in the Contract Labor Regulation and Abolition Act, there is a section 10 which lays down the process of abolition of the contract labor in certain activities. So the intent of the code by putting this clause is the same. So whatever is happening under section 10, the same thing is stated here, reproduced here. So basically the employment of contract labor in core activities is prohibited, provided that the principal employer may engage. Now there are certain circumstances when the in this code principal employer is allowed to use the contract labor even in core activity, but only in certain circumstances. So provided that the principal employer may engage contract labor through a contractor to any core activity if there is an in the normal functioning of the establishment is such that the activity is ordinarily done through a contractor. So this is a similar word of the existing section 10. Then, or the activities are such that they do not require full-time workers. So this is another aspect. Any sudden increase in the volume, this is very important provision. Suddenly, see, if your factory has got certain average production level and order level, but all of a sudden you have got some sudden increase and new orders all of a sudden, so you can include for that meeting that suddenness or that kind of an abnormality, you can engage contract labor and you can ask them to work in the core activity also. So this has been allowed only in case of abnormalities, and the appropriate government may by notification appoint a designated authority to advise that government on the question whether the activity of an establishment is a core activity or other. So when there is a different there is a debate or there is a dispute, then the appropriate government may appoint an authority who will decide whether a particular activity is a core or non-core. Fine. The next one. Interstate migrant workers, we have already discussed, friends, about this. So this has been considered by the government considering the recent pandemic situation. I think that situation has really probably influenced the government to make so much of a emphasis on the interstate migrant workers, and the kind of benefits that they will be getting, they have also been made clear. So this is what is about the interstate migrant workers. The next one. Yeah, move to the next one. So building and fine. Now these are the penal provisions. So what are the penal provisions where they are mentioned? So section 83 deals with the maximum limit of the exposure of chemical and toxic substances in manufacturing process in any factory. Earlier, these limits were specified in Schedule 2 of the Factories Act. Under this code, these are not specified, and it is mentioned that the limits of exposure of chemical and toxic substances in manufacturing process in any factory will be decided by the state government. So there will be definitely some rules in this regard. Section 87 deals with the general penalty, which shall not be less than 2 lakh. So friends, penalties have been increased in all these codes by a huge margin. So you right now, when 20,000, 40,000 were the penalties, now they have become 10 times more. So this has also happened. Section 56 deals with a dangerous occurrence resulting in a death. Suppose because of some dangerous occurrence somebody dies, then the person responsible shall be punishable with an imprisonment for a term which may extend to 2 years, and with a fine which shall not be less than rupees 5 lakhs. Such a huge penalty for the case of death. So penalties have been really increased. Now section 107 1 subsection 1 of 107 deals with the compounding of the offenses and the procedure. So compounding means, suppose there is some offense any factory has committed and prosecution is likely to happen. Now under this situation, there is a provision given by the code wherein the employer can approach the authorities under this code and make a request, and they say that they can always say that yes, it's an offense which has happened and we will take care in future. So in such case, by paying the half the penalty, the prosecution will come to an end. It will not go for prosecution. So this is a compounding, but compounding will be allowed, friends, only once in a period of 5 years. Next one. Okay, but while in compounding offense, one thing is very important, the provision of imprison, whatever offenses for which there is a provision of imprisonment, friends, such offenses cannot be compounded. This is again a very general principle they have adopted. And offenses and penalties, we are still continuing. So general penalty for offenses is 2 lakhs, but which may extend to 3 lakhs. Section 95 1 section 95 1 2 3 4, punishment for causing obstruction to the facility. Many times it is not happening now, but of course in olden times it used to happen, especially in remote states like Rajasthan, or where backward areas where inspector would go, he would be obstructed. So if such thing happens, then the employer is punishable with imprisonment for a term which may extend to 3 months, or a fine. This is or provision which may extend to rupees 1 lakhs, or with both also. So this is what is important. Suppose second time if somebody is convicted, imprisonment of 6 months, or fine which shall not be less than rupees 1 lakh, but which may extend to rupees 2 lakhs, or both. And for non-maintenance of the registers, records, and non-filing of returns, etc., penalty which shall not be less than rupees 50,000. So these are the petty offenses we call, small offenses, but even for that the penalty will be rupees 50,000, and it can further extend up to rupees 1 lakh. And section 103 1A, subsection 1A and B of section 103, they talk about 50% of the fine as compensation. So this is for this 50% of the fine is usually in case of any fatal accident. Suppose whatever is the fine, of that 50% will be given as a additional compensation to the heir or the nominee of the deceased person. So this is a provision which is there. Yeah. Next one. Safety related. Yeah, one question is also I can see from Manoj Pathak. Manoj Pathak is asking about FT. Okay, Manoj, I will definitely talk to you. See, I will see how much time we are getting for these questions. Otherwise, definitely we will revert to you with all your queries on these questions. Now, I would just request Fagun bhai, it is 4 o'clock. So Mr. Shailesh Raval still have another, I can still take 10 minutes. So Fagun bhai, if you can take that wages definition, can you show if it is possible? Fagun bhai.
Next. Yes, sir, sure. Let me share it. Give me 1 minute.
Shailesh bhai, you are after 5-7 minutes you can take over. I'll just now need only 5 to 7 minutes, not more.
Sure, please carry on.
Yes, yes. Manoj bhai, one question I can quickly answer your question. BOCW. Now, what is happening if you have got already that factory is covered under the Factories Act? Then the question of BOCW getting applicable will not arise, because there are also Supreme Court judgment also in this regard. Okay, now friends, this is a common definition of wages in all the labor codes. I think in the past also Hiren bhai has done a very good job by organizing such seminar and conference on code of wages and all. But still, friends, once again, I would like to throw some more light on the definition of wages, because this why I'm explaining to you. I'm not doubting what the previous faculties have done. They must have also explained to you. But friends, because I have studied this definition in the last almost, you can say, I must have read this definition at least 40-50 times, and every time when I read this definition, I am getting something new. So that is why, and apart from that, I have discussed this definition at length with a lot of senior advocates also. So whatever I I could understand out of this. I think all of you should also understand. And let me tell you that even after so much of a debate and discussion with senior advocates also, there are some people who still have differences about the understanding of this definition. So friends, remember this idea of this code is to make things simple, but many times, this will really become very difficult. If you read word to word, probably, and yeah, I think it is not so simple as it is intended to be. I think PPT of this will be shared. Don't worry. So this need not be. You be rest assured, Shilpa, Ben, on this. Yeah. Okay. Now, friends, just I'll spend 5 minutes. So, definition of wages in all the four codes, the same definition is there. Idea is to standardize. So, we will start. Wages means all remuneration, whether by way of salaries, allowances, or otherwise. Please remember these words, or otherwise. So there are certain companies which give salary and they have got different allowances. And even other than salary and allowances, there are certain other fashion also in which some remuneration is given. Some companies have a practice of giving conveyance allowance by not giving money, but they give a petro card to the employees. Or some companies, for the managers and officers, they give bonus that is okay as per the law. But whatever in addition to that, they have a tendency to give some gift card, or let us say some companies give Sodexo passes. Now, all these things will fall in the otherwise portion. Okay. So here, friends, that otherwise has this meaning, expressed in terms of money or capable of being so expressed, which would, if the terms of employment expressed or implied were fulfilled, be payable to a person employed in respect of his employment or work done in such employment. Yeah. So this is fine. Yeah. Move to the next one. Okay. Now, friends, this wages definition. So wages includes basic pay, dearness allowance, and retaining allowance, if any. So basic pay and dearness allowance, most of the companies are giving. So that is the only included portion. However, the wages definition is further saying that it does not include. So what it does not include is the items are from A to K. These items are not included, but the things are made more complex by the other part which is coming in. Friends, see the next one. Now, friends, this is the first. There are two proviso clauses to this definition. So the first one of this clause, that is very important, provided that for calculating the wages under this clause, if payments made by the employer to the employee under subclause A to I. Will you please take it to the previous slide? Now, subclause A to I, please see. So any bonus payable under any law for the time being, then the value of house accommodation, or the supply of light, water, medical. Now, in Baroda, there are many companies. Previously, even some GIDC companies were giving houses to the employees, and they were also giving electricity and water and everything. So this, the value of that is included. Our public sector and the units or the government sectors, they are also giving this facility. Suppose GIPCL, for instance, they are giving this. So the value of such accommodation and supply of light will be falling. So this is not included in the wages. Okay. Any contribution paid by the employer to any contribution towards any pension or provident fund. Now, this is actually not to be included. But if we go through that, this A to I items, HRA and remuneration payable under any award or settlement, or by the order of the court, or any overtime allowance, or any commission payable to employee. So these A to I items, yeah, go to the next. Now these A to I items, if the sum of these items, if it is exceeding 1/2 of the total of this, inclusion and exclusion, then such or other such person may be notified by the government of all remuneration calculated under this clause. Then the amount which is exceeding by 50% or 1/2, or maybe whatever is the percentage notified by the government, then such excess shall be deemed as remuneration and shall be accordingly added to the wages which are there in the included portion. That is the basic. So they will get added, friend. So remember this very, very carefully. This aspect is very important. And then second proviso clause. Okay, second proviso clause is fine. This is general. There cannot be any discrimination on the ground of the gender. So for the male you are giving one thing, and for the female you are giving different thing. So this you cannot have any discrimination with reference to D, F, G, H, which are there in the previous slide. Yeah, the previous slide. D, F, G, H. D is conveyance allowance, F is HRA, G is a remuneration payable under any award, and H is overtime. So on these items you cannot have any discrimination between men and women. So this is, and now the last part, the explanation part, friends. This is very, very important of the definition of wages. I thought of, what it talks about is very clear. Will HRA be also included in wages if total salary exceeds 50% of basic salary? Will HRA be also included in wages if total salary exceeds 50% of? Fine. On this question, Mr. Bhatt, I think I will need some clarification from you. But one thing is very certain. If HRA is there, if it is falling in, yeah, it is falling in A to I. Will you please go to previous one, please, once again? Yeah. Now HRA is, yes, falling in A to I. So, Mr. Bhatt, this is with reference to your question. Now, HRA, see, we are not concerned with HRA or anything. If it is falling in A to I, so what you have to do is that, let us say the inclusive portion of basic dearness allowance is, we call it as package basket A, and we call the exclusion which does not include. So whatever items are there under this not exclusion portion as basket B. So we have to total up basket A and B, and then whatever is the total, if it is the basket B is more than 50% of basket A, then whatever is the addition, we have to treat that addition as a part of the inclusion, so that will become a basic pay. So example, simple example, the total of, let us say, basic and dearness allowance is 4,000. Okay, and the total of basket B is, let us say, 3,000. Just example I am giving. So it is more than 50%. So 1,000 rupees is more. So this 1,000 rupees more will be considered as, it will be shifted to the basic. This is a simple example I have given, but I think I will give you one calculated sheet also. This Hiren Bhai, I will share with you. Yeah. Now move to the next one. Yeah. The explanation part now I am explaining. So where an employee is given in lieu, it is lieu, not leave, in lieu of the whole or part of the wages payable to him. Any remuneration in kind. Suppose if the employer is giving something in kind to the employee by his employer, the value of such remuneration in kind which does not exceed 15%. So basically the act is, the code is saying that if such value is not exceeding beyond 15%, then of the total wages payable to him, it shall be deemed to form part of the wages. So it is restricting. So up to 15% of this value will be considered as the part of the wages. So this is very important, friends. So this is required, and very high. Yeah, Mr. Bhatt, comment I can read. So this will surely impact very high while calculating graph. Yes, these are all implications. So you're right. it will see, there will be a lot of pressure on the employers, because the cost escalation will happen. But fortunately, this is a time for all of you to be ready, because most of the companies, your increments will happen in April. So you please start putting your application of your mind, so that your liability can be further reduced, and your structuring, you can do it in a right way. Yeah, food coupon as choice pay can be considered. Yes, absolutely, Soham, you're right. So friends, I think this is what I took slightly more time while explaining the wages definition. But with this, I think Fagun bhai, I am coming to the close of my this thing now. Shailesh bhai is ready, so next portion would be handled by Shailesh bhai. So thank you very much, dear participants, for giving me this opportunity. Thank you.
Thank you, Palkar sir.
Thank you. All the best, Shailesh bhai.
Yeah, thank you. Yeah, I think for some of the participants, it might be overdose. Palkar sir, इतना डिटेल में बताया गया.
No, but it is very, very. I don't know whether even I am a learning. I am student, so I don't know whether I have been able to explain to the satisfaction. But we will enjoy. Yeah.
So let us start with simpler things. Let me by analysis of what has happened actually.
Yes.
Yeah, central government, our BJP government, Narendra Modi team, they are working on to minimize the number of legislations actually. So
Yes.
because we have many acts, and many acts are not at all relevant in current scenario. So what
Correct.
they are doing, they are merging several legislations to minimize the number of legislations. So that is actually a good part. Numbers will come down, but end result is instead of simplifying the legislation, those are becoming very, very complicated. So earlier we compare earlier Factory Act and this OSH code. This OSH code is very much complicated compared to earlier simpler Factory Act. Because there were many new things we in our factory normal working hours, those are not connected with us, like mining, plantation. Those things are not connected to us, but those are there in Factory Act now. In OSH code, those are there. So many new terms are added in this OSH code. So let me simplify that thing. In this OSH code, it has total 14 sections. So Palkar Sahab has touched upon many sections, and total 116 sections are there and 14 chapters are there. And to include various type of segments like plantation, consultants, shops and establishment, they have included many parts in that chapter 11, that is contract worker chapter. So those 14 chapters are, first chapter is preliminary sections, in that definitions are given. Chapter 2 is about registration process, because that entire registration process will change. Earlier we used to have factory licensing, etc., 2 years, 5 years licensing. That will be changed now. It will become online registration. So once that OSH code will come into place, we have to get registered, because now customers of this OSH code are many segments, are not only factories, but many shops are there, many consultants are there. So those, even PPE, safety equipment suppliers are also part of this code now. So this is about chapter 2. Chapter 3 is about duties of the employee. It is not the now many users are there for this code, so duties are defined for all those things, like employer is one of the affected party. Same way employees are there, and all PPE suppliers, even consultants, engineers, architects, whosoever are in building and construction act is there. So all builders or architects, whosoever are designing the plant, whosoever are designing the equipments, those are also included under this OSH code under that duties part, chapter 3. So we here it's a very short words it is written, but in detail it is mentioned. It is affecting the all this. Even designers, whosoever is import the equipment, they have to also design the equipment. They have to provide the equipment in such a fashion so that it is not affecting the safety of the users. So product safety is also included in this OSH code. So this was about chapter 4. Chapter 3 was about duties. Chapter 4 is about functioning of this OSH code. It is mentioned that there will be board. One is at national level board and another at state level board. So those boards would be there. At present, there is no clarity, who would be the owner of that board. It might be like, we have Gujarat Pollution Control. A similar kind of board will come up to take care of this safety. So national level and state level, two kind of boards are suggested in that OSH code. So in chapter 4, it is mentioned that way. Presently, I am just summarizing the entire OSH code. So it is not there in slides, but just, it would be easy to remember you. That's why I am summarizing that thing. Chapter 5 is about working conditions. That chapter is almost similar to existing Factory Act in that working condition is mentioned here. Chapter 6 is about welfare provision. Little bit of change is there, but most of things are there in Factory Act. So they have straightway taken in that chapter 6. Chapter 7 is about working hours and wages that Mr. Palkar has explained very well. Chapter 8 is about registers and records. That also touched upon by Mr. Palkar. That is also almost similar to existing Factory Act. Chapter 9 is little bit different. Here it is about how it will function. Who will be the inspectors and who will be the facilitators for this OSH code. So section 34 to 42 are there in chapter 9. Chapter 10 is entirely new. That was not there in Factory Act. It is about women employment, because women empowerment is going on in big way. So that chapter is added. Working hours has been extended for women, and many facilities are to be provided by the employees in that chapter, women employment.
So should I change the slide also?
No, it is not there in slide. I'm just summarizing. Afterwards, we'll look at those slides. Okay.
Okay. Okay.
So that everybody can quickly remember this entire OSH code. I'm trying to summarize entire OSH code.
Okay.
Chapter.
Yes. Good.
Chapter 11 is about contract worker. So this chapter is entirely new. That wasn't there in Factory Act. Here, because many custodians are there in this OSH code, mining activities are there, shop and establishment are there, building lobby is there, consultants are there. So even plantation people, those are also there. So various kind of contract workers are defined over there. Migrant worker, there's in big way it's described here in OSH code. It's about contract. So chapter 11 is there, and under chapter 11 there are different 8 parts are there. So 8 type of different contract workers are defined over there. So this is an entirely new edition, unlike this Factory Act. Chapter 12 is about offenses and penalties, about the violations, addressing the violations part. Chapter 13 is about Social Security Fund. This little bit new, but it is for the betterment, because this new government wish to provide pension to everybody. So that Social Security part is addressed in this Factory Act, OSH code. And chapter 14 is last chapter about miscellaneous things are addressed. So total 14 chapters are there in this OSH code. Okay, out of that, if we want to touch upon safety, so basically chapter 4, 5 are related to safety only, and almost safety is covered in entire OSH code at various places. But these 4 chapters are dedicated. Chapter number 3 and 4 are dedicated for safety. Earlier, only chapter 4 was there in Factory Act for safety. Now here, chapter 3 and 4 are added in that thing. Okay, so now we'll look at these slides. Chapter 3 is about duties of employers and employees. Okay, so heading is about duties of employers and employees, but in that chapter, duties of many other people are also mentioned. Like, duties of equipment suppliers, duties of builders is also mentioned, duties of architects is also mentioned over there. So what are those things that we'll discuss over here? Basically, intention is to ensure that workplace is free from the hazards and it is safe for the person who is using that thing. And here, one of the duty is mentioned is comply with occupational safety and health standards. This is, new terminology added in OSH code. They have used the word standards. Earlier, those things were not there. Now, what are those standards? That is not defined in this OSH code. So that means board, which is mentioned in this code. So that board has to come out with those standards. So we'll be getting those standards. What are these safety standards? At present, that is where NIOSH, various, we follow OSHA standards, American standards, but there are no Indian standards for those things. What are the lux level? What are the working condition over there? What are the working temperature? Many things are there. Majorly, we are following, from the other countries. So for Indian things, those standards, board will come out with those standards. When standards are there, then they will be asking for measurement of those standards, and then we have to maintaining those standards. It is tell that things which can't measure can't improve. So in safety at present, all measurables are lagging parameters, means they are measuring with accidents only. But here proactive approach is taken. So what are the things we need to do to prevent the accidents? Those things will come up in this standards kind of things. So they have used that thing. And certain things has to be free, like medical examination has to be available free of cost to the employees. Those things are mentioned in that thing. Now, in section 6 also, another thing is mentioned that providing and maintaining the reasonably practicable working conditions and environment, disposal of hazardous and toxic waste, that is also mentioned. Letter of appointment to every employee, Mr. Palkar sir has explained those things. We have to provide the appointment letter to all the workers. That is also mentioned as a duties of the employer. And another thing mentioned is about arrangement for workplace safety, and that workplace has to be absence of risk. Okay. And section 8 is about duties of designers, manufacturers, importers, and suppliers. Okay. Slide, it is section 8 is written, that is about the designers, importers, suppliers. So that is entirely new things that wasn't there in Factory Act. So means designers means who is providing the designing of the plant, whoever is constructing the plant, designing of the equipment, also it is covered in that thing. Whoever is supplying material to us, that is also covered in that thing. So it would be like product safety kind of things. Even our PPEs, personal protective equipment, that has to be based on certain design standards they have to follow, and certain standards will come up. At present, we are following European standards, but certain Indian standard will come up afterwards. that we have to use such kind of equipment. Some of the Indian standards are there, but most of places it isn't there. If for imported safety equipment, those standards will come up. So in section 8, it is mentioned that duties of so employer is not only the person who is employing us, but it includes designers, importers, suppliers, and everybody who is product being supplied to us. So that is for the benefit of the consumers. Section 9 is about the architects, project engineers, and designers. It is extension to section 8. So they have to design the plant, equipment, etc. in such a way so that minimum risk is there to the user. And they have to maintain the equipment and upkeep of the structures and buildings for the whosoever is using that thing, and special hazards is minimized. Section 12 is about workers in the establishment contracts. Any disease specified in the third schedule means that is basically where insecticides, agrochemicals, special kind of industries are there. It is touching upon that part. So this is about the duties of employer, but it is very larger. It is documented in a very larger perspective. Okay, so let us move to next slide. So that was about duties and responsibilities. Here, responsibility of employees also defined. They will not be indulging any horseplay kind of things, and disciplinary action can also be taken against employees. That is also touched upon that earlier, chapter 6 and 7. Now, section 10 is about notice of certain accidents. That is almost similar to existing Factory Act. We have to give the inform to the respective regulatory body about those accidents. So here various chapter section 10, 11 and 12 is there about they have defined mishappenings in 3 ways. Is about certain accidents, means physical injury, also about the dangerous occurrence, that is also same as Factory Act, and about the occupational disease. Let us move to next slide. So chapter 10 was about accidents. Chapter 11 is about certain dangerous occurrence. This is almost similar to Factory Act, so that's why I'm not going in depth of that thing. Okay. Next slide. So chapter 12 is about certain disease. So notifiable disease are there. That annexure is same as of existing Factory Act. So chapter 10, section 10, 11, 12 means chapter 10 is about injury causing 48 hours of lost time. Chapter 11 is about dangerous occurrences. Person has not injured, but dangerous occurrence has occurred, like fire kind of things, toxic release kind of things. Those are covered under section 11. And notifiable disease means any respiratory kind of disease or audibility kind of things, or any substance which cancer causing substance, etc. Those are covered under section 12. Okay. Next slide. Section 13 is about duties of the employee. So here more emphasis is given about the discipline to be followed by the employee. So we have to be careful in that thing. Responsibility lies with both. Employee have to follow all the rules specified by the employer. Basically, it's a win-win situation. C is mentioned, cooperate with employer in meeting the statutory obligations of the employer under this code, report unsafe and unhealthy conditions. So certain terms are like we follow in ISO 45,000, OSAS 18,000 earlier, it was there. Such kind of things are mentioned over there. It's a participative approach involving workers in the safety. part of the things are there in Factory Act, but it is here making employee part of the safety to improve the safe working culture. So safe working culture is touched upon by this section. Next slide. Now certain rights of the employees are there. That is almost same in 68K our Gujarat factory rules. It is mentioned in larger perspective. It is taken over here. What are the rights of the employee? They need to know what are the health and safety related issues over here. And employee has to communicate them about the immediate danger of those things and what are the hazards in that thing, and they have to take corrective measures in that thing. And here very important term is there, employee has right to communicate to the inspector come facilitator. These are new terms is added. At present it is not clear who will be the facilitator, etc. But things will be clear once rules are defined. So that facilitator will take remedial actions based on the complaint or communication by the employees. Okay, next slide. This section 16 and 17 is about advisory board. This is entirely new terminology in this OSH code. Is about there will be national level occupational safety and health advisory board. What they will do, that is also defined in this OSH code. There are three kind of type of activities are mentioned. One is that administrative control. They will be developing various standards so that that will be followed by the industries and manufacturers. They will also be carrying out research activity, and advisory role is also mentioned. They would be coming out with various training modules, how to advise the public, etc. So all three kind of planning, research, and advising. All three kind of activities are mentioned at national level and at state level. It is almost similar to our pollution control systems, environment protection kind of system. Like we have Ministry of Environment, Forest, Central Pollution Control Board is there. Same way at state pollution control board is there. And Ministry of Environment, Forest, they defines the standards, CPCB defines the standards, and everybody is following that standard. Similar kind of mechanism will come up over here under this advisory board. So things would be measurable in safety now. That is intention of defining things over here. So section 16, National Occupational Safety Health Advisory Board. Next slide is section 17. It's a State Occupational Safety and Health Advisory Board. At present, National Industrial and Occupational Health Safety Board is there. Similar kind of things will come up over here. Okay, so we discussed that thing. Next slide. Section 18 is about the defining the standards. So that board will be carrying out certain researches. They will publishing certain standards, and they will also define functioning bodies and monitoring systems. So section 16 is mentioned that what kind of that standards will be there, and schedules. At present, second schedule is mentioned over here, and that would be more relevant for that mining, plantation, etc. Things. In factory, many things are much more defined, but those things are not well clear in plantation, means agriculture, plantation industries, and mining things. Okay, so next slide. Section 21 is about collection of statistics portal for interstate migrant workers. These entirely new terms added in this OSH code because the entire chapter is new for those things, contract worker. So in lockdown period, we have seen those conditions. from another state to another state. Like in Gujarat, we see many laborers from Bihar and UP, etc. So how to control them? So this will be online systems, because it would be huge mass, crores of migrant worker would be there. So there will be online registration would be there. At present, what is happening? Like in high hazard industries, suppose in agrochemical industries, one person is engaged. What we follow, we relocate them. Once exposure is there for 6 months or 1 year, then a certain level of exposure is there, we relocate that worker to another industries or another area. But their record is not maintained. Online record is not maintained. So this is mentioned over here. There will be online portal. There will be registration of that worker, and their history will be maintained over here. It will be linked with Aadhaar, and it's a medical records, etc. That will be maintained over here, so that we can track each and every worker over here. This is a very huge task. It is basically touched upon that thing. Its infrastructure development may take long time, but intention of this section is that only, that record, health records, etc. will be maintained of each and every contract worker over here. This is a very good part for human being. Maintenance part, it would be very difficult task for the industries, but we have to improve upon those things. This section will lead us to have more improvement. Okay, next section. Safety committee, safety officers, these same kind of things in existing factory act. In factory, we follow those things, but those things are not common in building and constructions and mining, etc. But this will be common for all kind of industries now. So I'm not writing each and every word. In question answer session, we'll be discussing those things. Next, these responsibilities of employer. Yeah, this is basically responsibilities related to welfare and working condition. This separately mentioned in earlier chapter. It was there. Here it is mentioned in relation to working condition at the plant. So cleanliness and hygiene, ventilation, temperature, humidity, environment free from dust, ventilation, potable drinking water, prevent overcrowding, adequate lighting, sufficient arrangement for washroom, treatment of waste. Here now that board, they will come out with all numbers for all those conditions. Means cleanliness and hygiene, how it can be measured. They will come out with those numbers, and things will become measurable for those things. Like ventilation, temperature, humidity. At present, certain things are there, but that would be more visible now. Okay. Disclosure of information. At present, it's there in the Factory Act. It's the same way it is mentioned over here. So how employer will be disclosing the information about the imminent danger and health effect to the employees, and furnishing that information to the statutory bodies. Section 85 is almost same copy of existing Factory Act, specific responsibility for hazardous process. Various chapters are mentioned in existing Factory Act. Different hazardous processes are mentioned. Hazardous operations and hazardous processes are mentioned in existing Factory Act also. These same things is to be followed over here. Yeah, but word is added, like certain standards will come up against those things. At present, those measurable standards are there. How it will be measured, those things are not mentioned. That will come out over here. Now, what are the implications of that code? This again summarized in this table. A definition of factory is there. Here numbers are increased. Instead of 10 workers, it is 20 workers. and for hazardous process 20 workers. It's without power. If power is being used, then 20 workers. Then without power, it's a 40 workers. That is basically applicable for shops, offices, etc. Hazardous activity is changed over here. It's an establishment where any hazardous activities carried out regardless of number of workers. So this has become more stringent. You know, in summary of this OSH code, they have written that they have liberalized the labor laws and conditions, but many places they have made it more stringent. So this is more stringent now. Irrespective of number of hazardous activities there, it is called hazardous activity. Contract worker, Palkar Sahab has described very well. Building and other construction work, that is now included in OSH code. So that all conditions, earlier it was there in separate act, but it is included in this act. So it has been, condition is removed now. Daily work hour limit. Now it is fixed maximum limit of 8 hours per day. But as per the labor laws, it was defined, maximum daily limit was defined there. Employment of women, that is more liberalized in code. We can engage the woman for late hours also, and that provision is there because of IT industries, etc. Those are coming up. So woman empowerment kind of things are added over here. Crash facilities, here some vague term is used. Earlier it was 30 female, but now they have mentioned 50 workers. So that needs to be corrected. We are working on that thing. You know, instead of 50 workers, it should be 50 female workers actually, because 50 workers is a vague term. So we have to mention gender over here. Okay, appointment of welfare officer. This requirement has become more stringent. At present, it's a 500 workers, but now it will be 250. Canteen facilities, that has become more stringent from 250 to now it is 100 in OSH code. Next slide. Thank you very much. Yeah, now we'll take up question answers. Chandrakant, a factory inspector will be facilitator. I agree to that thing, but this OSH code is touching upon, you know, many other things also. So not only factory inspector, some other agency will also come up. Entire reorganization would be there. It is proposed at present, it's under labor ministry, it is coming up. But OSH code, how it would be board kind of functioning. So separate chairman and member secretary kind of things will come up. So entire mechanism would be different, and it would be more technical compared to administrative now. And they have to play more of advisory role. So such the intention of this entire code is like that. You know, that's why they have changed the terms. You know, they are calling it code, not the act. So this is a big change. So entire perception will change. Yeah, Shoham sir, there any specific site for it will be common for factories, site, etc. Yeah, that clarity Shram Suvidha portal. We do have. Okay. Many clarity will come up at present. You know, based on this code, feedback has gone to the ministry. Certain things needs to be changed. So from common forum like Chamber of Commerce, Indian Chemical Council, FICCI, ICC, they have given their feedback to the ministry also to make certain changes in that thing. So some clarity will come up in that thing. At presently, they have merged all those things, but many terms are vague. So they have to clarify those things. Okay. Factory still be considered in establishment for the purpose of chapter related employment facilities. Basically, establishment term they have defined separately, factory is defined separately. Mr. Parker will explain in detail. हाँ पालकर साहब है चले गए
I am there.
हाँ
Am I audible?
Yeah. So here establishment,
Yes,
now
yes.
establishment is new term added over here. Factory, both terms are there.
Correct. So establishment is basically other than the factory, because factory they have considered, they're very clearly given. In part 2 they have defined certain factories with 10 or more. However, in general the factory is wherein manufacturing happens. So establishment are different. Now one question I could see was about the canteen. Now somebody was asking about whether it should be subsidized or not. Now let me tell you, nothing is mentioned about the subsidy in the canteen. The only thing, if you go through the rules, Gujarat factory rules, they are talking about the current Gujarat factory rules with reference to the Factories Act. They are saying that there has to be a facility which has to be made available, and if food is being provided, then it will be on the no profit, no loss basis. So that does not mean that it has to be subsidized. So this is one clarity I wanted to share with some question. Raval Saab, there is one question for you for safety officer.
Yeah, I'm replying to that thing.
Yes, sir.
That based on number of safety officers, intentionally now this code is silent about that thing, but it is mentioned that state board will come out with detailed specifications about that thing. Like at present, it is mentioned that for hazardous process for 250 workers, etc. But this code is silent about that thing. It is not described. So we have to wait about those things. So what would be the process of common registration under CLRA factory? Yeah,
Contract labor and regulation. Yes, and the Factories Act. Yes.
Yeah. So that would be online registration that is mentioned, but some portal will come up.
Portal will. Yes.
What will be the process of common? Yeah, that we discussed. So many things, infrastructure needs to be developed to implement this code. That will come up. So that will be new things for us.
Palkar sir, can you switch on your camera, please, so everybody can see you?
Yes, please. Yes, friends. Okay. See,
from RC and factory license both are required in RC exempted. Yeah. Now factory license, once registration process will be effective, factory license may not be required, but that clarity is not there in OSH code. Here OSH code only registration is mentioned, factory license word they haven't used. So more clarity will come up afterwards. At present, it is silent about that. Barabar and Palkar sir.
Yes. Actually, what is happening, I learned from some of the senior ministry and the other people, our Gujarat rules are getting framed. They are in the finalization stage. I think we will be able to get them in another 15 days time. Most probably, of course, initially they will be the draft rules, and against which the suggestions and objections will be invited, and a period will be given, and after that they will become final. So this is what is likely to happen.
Next question is, when will the act be implemented? Their target is to implement in 1st April, but still I don't know whether they would be able to implement that thing. Because infrastructure, I don't know when they will. Once infrastructure is not there, then it will be a problem. Because big change is proposed in the way of working of the government machinery.
Yes.
Can incentive is considered as wages? Palkar sahab, आपका question है.
Yes. Now, very good question. Now, incentive. See, there are several judgments on the incentive aspect. production incentive. We have seen Supreme Court judgments, and many places there are certain incentive judgments which have considered, if it is a production link scheme and the scheme is not properly drafted, and it gives an impression that it is only a camouflage and a paper arrangement, then in that case it would be considered as a wages. Whereas if you have a proper incentive scheme, then there is definitely, because the wages are, in that case the incentive is not going to be fixed. It will vary from your production targets. So in that case, that will not be a part of the wages. So this is what I can answer at the moment on this.
So will overtime allowance be also included in?
Yes. See, overtime allowance, I think I had shown you, there were two parts of wages definition. One is the inclusive and the other is exclusive. Now in exclusive, overtime allowance is falling in A to I. So for the that is being considered. If it is inclusive of that overtime allowance, if your basket B, that is exclusion, is more than 50% of the total, then the additional portion will be shifted to the basic. Sir, what is the role of the safety, role and response safety officer, sir, as per the code? There is a question for you, Raval, sir.
The present question is Lenko Anpara cases. Is that BOCW would be applicable on expansion of factories? Still need some clarification from you, please.
Yes. So as I told you again, I'll just share with you, for the existing factories which are already working and expanding, and then there is an expansion happen in the same premises and precincts, then BOCW will not be applicable. But yes, if it's a new factory, then yes.
Here, there are three kind of condition. One is that entirely building construction activity. Second thing is entirely greenfield project of factory.
Yes.
The factory license is not taken, but project activity.
Correct.
So that is project activity. And third thing is existing factory is there and they are constructing the project adjacent to that thing. Factory license is there, but within that factory they are constructing another plant. So three different kind of condition is there. But now it is must, so we have to comply with all those things, isn't it? Palkar sir?
Yes.
This would be applicable everywhere.
Yes, but if it is an ongoing factory and there is an expansion in the same, then for that construction activity, BOCW will not be applicable. Pragnesh Bhai and some others who have expressed their thanks. So fine, we are happy. If we can add value, that is, thanks to actually Hiren Bhai, because he is a main source of inspiration for all of us.
Thank you very much, sir. Actually, Society of Human Resources given very good platform to all the HR, sir. So I am thankful to the Nishant and Ashish, even Bhavin Bhai for giving this webinar platform at free of charge, and Crown HR for continuously supporting us. Without that support, we may not able to give you such a very good platform to each and every one. Because I see that more than 170 participation are there. So it is a very big platform. If we are going to the women, it is not possible. So particularly Bhavin Bhai supporting us for the webinar. So it will, because in that how many members are there, we are not knowing, but it is capacity of 5,000 members. Bhavin Bhai have this facility of webinar. 5,000 members can join this webinar. So thank you. I am possible for the this very kind support for this, and we would like to conclude because time is already happening. So thank you very much, Palkar sir, Raval sir, for highlighting our SHRP and whomever joined this session, because I think there are so many learning from this session, because I think this topic is not touched by anyone. Right, Palkar sir?
Yes, sir.
Yeah.
This topic,
Yes. And Raval sir has done. Raval sir has explained thoroughly.
Yeah.
Yes.
So I think you have given lot of weightage and justification to topic, and I know Palkar sir has given made lot of preparation for preparing this PPT and everything. So thank you very much, Palkar sir. Thank you, Shailesh bhai. Thank you very much. Thank you all of the SHRP member and all for the participation in this webinar. Thank you. Thank you.
So all the questions we will answer, Hiren bhai. You compile everything, because there was one good question of Raval by Amin. That was a very good one on telecom industry. So I think we will definitely get back to all of them within a week time.
Yeah. Okay. Thank you, sir.
Thank you.
Thank you.
Thank you. Thank you.